extradition cases and in domestic prosecutions, and most recently he represented Josh Walker successfully, who was, when he returned from assisting the YPG in Rojava. Alastair.
Thank you. The work of Jan Thurman and the principal decision of the Belgian Court of Appeal is undoubtedly a hugely important moment, and one that should encourage all lawyers and activists in this country to consider what more could be done here. The decision to prescribe the PKK in the UK is looking ever more fragile as each year passes, and particularly in the light of the rapidly changing regional politics in which Kurdish groups have in fact become the bulwark against terrorism. Maybe a little history first, and I apologise because Les has dealt very briefly with some of it, but how was it that the PKK was prescribed here? Well, as Les has explained, it was a consequence of the Terrorism Act in 2000, and the way in which it was done was entirely arbitrary and unfair. It was clearly designed, in fact, legally to try and prevent any proper scrutiny or challenge. There was a list of 21 organisations, including the PKK, was presented to Parliament on an all-or-nothing basis, with almost no debate. There was no published criteria as to how the Secretary of State would exercise his discretion to prescribe an organisation. He could prescribe or not whoever he wanted, and there was no way of understanding the rationality of any decision. The definition provided in the Act of Terrorism was so overbroad that it prescribed any organisation such as the PKK that was entitled to engage in armed conflict under international law and exercise the internationally protected right to self-determination, which specifically allows such a challenge. Now, the difficulty in formulating an objective definition of terrorism and the resulting potential for arbitrary political decisions is well known. It doesn't appear to have troubled our legislators at all. In Canada, for example, they grappled with it, and the Supreme Court of Canada considered an argument that the term terrorism was subjective, so subjective in its meaning as to be void for vagueness. Although the court rejected the challenge, it emphasised the risk of abuse, where a legal definition depended on essentially a political judgment. And this is what the Supreme Court in Canada said some years ago. One searches in vain for an authoritative definition of terrorism. There is no single definition that is accepted internationally. The absence of an authoritative definition means that, at least at the margins, the term is open to political manipulation, conjecture, and polemical interpretation. Even amongst those who agree on the definition of the term, there is considerable disagreement as to whom the term should be attached. Perhaps the most striking example of the politicised nature of the term is that Nelson Mandela's African National Congress, which during the apartheid era routinely labelled a terrorist organisation, not only by the South African government, but by much of the international community. And as a reminder, as Les has pointed out, the definition of terrorism in the UK under the Act is simply the use or threat of action designed to influence the government or to intimidate the public or section of the public for the purpose of advancing a political, religious or ideological cause, essentially all political movements. It is completely silent as to any of the international law issues regarding relation to the right to self-determination, as considered in the relevant Belgian legislation. Furthermore, the Act created a series of offences designed to prevent any support of a newly designated terrorist organisation expressing their support for that organisation, regardless of the representative nature of that organisation within a community, contrary to their right to freedom of expression, including the right to impart political information. And as if this wasn't enough, there was one route was created for the challenge of this decision to prescribe, and that route was declared to be the Prescribed Organisation Appeals Commission, which is clearly unfit for purpose for two primary reasons. As we have seen, the definition of terrorism is so broad that it would be easy for the Secretary of State to justify the decision to prescribe any particular organisation. Interestingly, at the time of its prescription, the PKK was not actually engaging in anything that could be described as terrorist activity, as it had been on a ceasefire for some years. But the Act itself allowed the Secretary of State to designate an organisation which had been involved in violence in the past or might be in the future. That's an example of how broad it is. The basis for legal challenge through the POAC route is essentially so narrow that it would be in practice necessary to require a court to substitute its view of what national security was for that of the Home Secretaries, something courts have historically been very reluctant to do. Regardless of its legality, the practical lack of necessity for the decision to prescribe has been demonstrated by events in this country ever since prescription. As Les again has touched on, there's been a campaign of resistance. Although many members of the Kurdish community have been harassed and targeted as well, including sometimes via arrest, what is perhaps interesting is what has not happened here. For example, there have not been numerous arrests and trials for membership of the PKK or for fundraising activities, despite it, for example, being said by the security services in my presence to particular individuals, we know who you are, we know where you fundraise, and we know how you do it. So why aren't they being prosecuted if they genuinely believe that criminal offences have been committed and if this law of prescription has any legal merit? What appears to happen is that when it suits, particularly perhaps before the visit of a Turkish dignitary, members of the Kurdish community have found themselves subject to house searches or have their community centres raided and the like. In other words, the claimed executive purpose, the prevention of terrorism, has simply not been borne out by a consistent state practice. Everything appears entirely arbitrary. The truth appears to be that what prescription is about something else and something illegitimate, the use of the criminal justice system through the stigmatisation of prescription and a subsequent label of terrorism to try and delegitimise a lawful political cause to meet a foreign policy objective. Now, of course, that foreign policy objective has perhaps changed more recently, and the arbitrariness of prescription has become even more apparent by events that have been happening, particularly in Syria, where Kurdish forces have been the cutting edge of the struggle against ISIS and are overtly supported by the West. This has caused the police over here some problems as they grapple with the new landscape. I recently represented a young man who came back from Syria, where he'd been assisting the YPJ. And he was asked by the police in an interview whether he'd ever been trained in guns, and he said yes. And they asked him, well, what? Have you ever used an AK-47? He said yes, when the Americans trained me. The police moved on rather quickly and chose not to take any action in relation to this apparently damning admission of a terrorist offence because it just simply didn't suit the political agenda. Instead, in fact, they chose to prosecute him under the Terrorism Act for possession of an ancient and useless partial copy of a freely available book, the Anarchist Cookbook as it happens, which he'd forgotten he had and had acquired in relation to a university group of which he was a member and in which there was no dispute where he had it. Fortunately, a jury acquitted him very quickly, him having chosen to tell them about his experience assisting Kurds in Syria and how insulted he felt to be accused of terrorism because he was charged under the Terrorism Act. Indeed, in general, when fighters have gone to assist the YPJ, their experience on return to the UK has been a complete lottery, but none have yet to be prosecuted. Some have been Schedule 7, that process where you're stopped coming into the country and asked questions on a compulsory basis and released. Some have been arrested and bailed and then told there'll be no further action after several months. Some have been Schedule 7 and then arrested, and some have simply been allowed to return without any form of executive action at all. This undoubtedly reflects the fact that the 2000 Act cannot work, and it does not work, as a rational legal tool of the criminal justice system. It's seemingly based on arbitrary and unpredictable political whim. Indeed, somewhat ironically, this was in fact prefigured in the debates prior to enactment, when criticism of the potentially broad reach of the Act and the lack of legal protection of those legitimately engaged in fighting was met with a bald assertion of the common sense of the prosecution authorities when deciding to arrest and prosecute. To say ironically, it was on the subject of Kurdish opposition to Saddam Hussein, and this is what was said in Hansard. Douglas Hogg raised it. I'm sorry to interrupt the right honourable gentleman, Mr. Straw, but I think this is a serious matter. Kurdish representatives came to see the then Foreign Secretary, the then Prime Minister and me to obtain our support for their campaign to drive Saddam Hussein and his army out of North Iraq. On the face of it, that falls within the scope of action capable of constituting terrorism under Clause 1. I understand the right honourable gentleman to be saying, not that I'm wrong, but no one be prosecuted for encouraging the Kurds to take such action, because of the discretionary power of the prosecution authority. That is, however, a profoundly unattractive situation, and the reply came as follows. I simply do not accept the proposition. The idea that in this country the police would investigate such an alleged offence, in respect of Iraq, that the Crown Prosecution Service will bring a charge and the Director of Public Prosecution will give his consent cannot exist outside the Right Honourable and Learned Gentleman's fevered imagination. In other words, what was being said was the only potential protection really is not in law, but in the willingness or otherwise of the police or prosecution to bring a prosecution or not, should they choose. This cannot be a remotely satisfactory route for any individual to understand what the law is on such an important issue. Legality here being only discernible in retrospect. So if I just may conclude, if the law denies an international right to self-determination, is arbitrary in its use, and is entirely unforeseeable in terms of its breadth, it cannot be a good law, and it must be capable of challenge, legally as well as politically. Once again, I thank our Belgian colleague, Jan Furman, for the work he has done and for reminding us of the duty now in this country to build on what he has achieved and to begin that challenge here.
Thank you very much, Alastair.